Hi, and welcome to Legal Talk. I'm your host, Stacy Clark, and today I'm so fortunate to have one of our area's top employment lawyers as my guest. Welcome, Ethan O'Shea. Ethan chairs the employment law practice at Montgomery County's prestigious law firm Hamburg, Rubin, Mullen, Maxwell, and Lupin, and he's also the chair of the Montgomery Bar Association's Employment Law Committee. On a daily basis, Ethan is counseling employers of large and small businesses as to how to stay in compliance with Pennsylvania state and federal employment laws. He also litigates discrimination, non-competes, and wrongful termination matters. I've not yet had the pleasure of watching him in court. I've heard he's an amazing trial lawyer to watch, and I look forward to doing that someday. His cases cause him to appear before the Pennsylvania Human Relations Commission, the Equal Opportunity Commission, and federal and state courts throughout Pennsylvania. Prior to joining the firm, Ethan was a senior deputy DA with the Bucks County DA's office, where he prosecuted a wide variety of criminal cases. So criminal defense law is still a part of his practice today. In addition to chairing the Montgomery Bar Association's Employment Law Committee, he's also the past president of the Montgomery Bar Trial Lawyers Association. That's a lot of work, so when not practicing law, Ethan is an active, homegrown, and longtime resident of Radnor Township. You can find him most weekends coaching or cheering on his 3 kids in local youth sports programs. Okay, everyone, grab a chair, pull on up, and let's learn what some of the hot legal issues are right now affecting employers and employees. Thanks for being here, Ethan.
Thank you for having me.
So let's jump right in. I have this feeling your phone is ringing off the hook. What are some of the biggest questions you're getting today from employers?
Well, it won't come as a surprise. It's pretty much everything COVID. The questions have changed a little bit over the past year, but COVID is still dominating my office for my personal employment law practice. One, and you won't be surprised, it's vaccinations.
Okay.
Must employers give them? Should employers require them? 2, it's people who are out on leave or want to be out on leave because of COVID concerns. So while I'm still dealing with issues that I was dealing with before COVID, I would say those 2 issues dominate my days.
Okay, so right now we're still in COVID. We're still allowed to work remotely according to Governor Wolf. What are some of the changes that employers face today, in the next few weeks, going into late spring, would you say?
Well, it's dealing with the remote workforce.
Okay.
Obviously, more and more people have been working remotely over time, but for some employers, this was completely new. And for many employers, it's still required. The governor's order is still in place. And for those non-healthcare companies, if their staff can work remotely, they are to be working remotely. And that creates a host of issues. It's still the employer's job and responsibility to keep track of hours, to make sure wages are paid in accordance with law. It creates issues with employees using their home computers and their own telephones. What lawyers in my field typically call bring your own device to work is now the norm with people working at home. So it's just a different world. Employers have to live in it.
Okay. It sounds like there's some compliance issues there that employers have to be cognizant of.
Well, there are. When employment law is discussed, it's all about regulation and laws. And there's a host of federal laws and state laws that govern pay issues, leave issues, and mandatory overtime issues. And it's the employer's responsibility to know this and comply with this. It's not on the employee to comply with the law, it's on the employer.
That's important. So tell us about the rules about vaccination and workplace right now. Can an employer require someone to get vaccinated to have a job?
Well, the short answer is yes, with some exceptions. Pre-COVID, there were certain employers that were requiring vaccinations for, say, the flu. That was usually in the healthcare industry because we don't want nurses and so forth getting patients who are very vulnerable sick.
Yes.
So mandatory vaccinations have been authorized in the past, but not on the wide scale we're talking about now. But most employers can, if they choose, require their employees to be vaccinated. There is some concern that because the vaccination was approved on an emergency basis, perhaps they ought not be doing that, and it's a little bit unclear, but common wisdom is it can be done. But The answer doesn't stop there.
Here's the but.
If employers want to require their employees to be vaccinated, and some do and some don't, they must make certain exceptions. One is if an employee has a sincerely held religious belief that makes them not want to get vaccinated,
Sure.
the employer has to honor that. Two, if there's a legitimate health concern, the employer is going to have to take that into account. And if not, you could be talking about an ADA problem. That's Americans with Disabilities Act.
Okay.
So while you can require it, know that you may have to make certain exceptions. Now, in my mind, the legal issue isn't as important as the practical issue. The legal issue we can deal with. I can talk through an employer saying, yes, you can require this. Here are the exceptions. And if an issue comes up under one of those exceptions, we can deal with that too. I believe the practical issues about requiring a vaccine outweigh the legal issues. If you are going to have a policy that says you must be vaccinated or you can't work, you have to think about the next step. What are you going to do when an employee or group of employees say, I don't care what the policy is. For whatever reason that has nothing to do with religion or my personal health situation, I'm not getting vaccinated, and you don't have the right to tell me otherwise. Are you going to discipline that employee? Or are you going to terminate that employee? Are you going to discipline or terminate a group of employees? I had an employer recently poll a group of 30 employees, and only 2/3 were going to take the vaccine.
Huh, interesting.
If 1/3 of the workforce says, I'm not getting it, now what are you going to do?
What are you going to do?
Right. And that's not a legal question.
Right.
That's a business decision. And I try not to step in the way of clients making what is right for them from a business standpoint. And you have to be careful if you're going to enforce this policy but not another unrelated policy. Are you going to be treating different people different ways for different violations?
Oh.
So there's a lot to think about if you're going to be mandating vaccines.
Okay, so we've talked a little bit about remote issues, people working remotely. Are there any other things that you want to raise today about what an employer needs to be on top of other than hours, payroll, things like that involving a remote working employee?
Well, when you have a remote worker, and I think I touched on this a moment ago, they're not sitting at their desk using your supplied hardtop computer.
Right.
They might be using their own laptop. They might be using their own phone. You now have privacy issues if you want to be checking on what they're doing, who are they communicating with. There may be security issues. Are they going to be sharing this information intentionally or otherwise because they have it on their own phone, because they have your documents at home?
Yeah.
And that's a balancing act.
So what are you advising businesses to do, no matter whether they're large or small family businesses, to do right now as the economy slowly recovers? Are there things you'd like them to be keeping in mind?
I think it's a perfect opportunity to take a step back while you have a little bit of time, because not everybody is in the office, because maybe business isn't quite what it was a year ago.
Yeah.
And as you gear up, it's the perfect opportunity to take a look at your big picture. Do I have written policies where I need to have them? Am I paying my employees correctly? Am I classifying them appropriately as employees or independent contractors? Am I classifying them appropriately under the Fair Labor Standards Act as either exempt or non-exempt? And when we talk about that, it means, by and large, do they have to get overtime pay or do they not? A lot of employers, particularly employers that started with 1 or 2 employees and have grown into 20, 30, 40 employees, never really thought about these policies or these practices. But now you have to. And now's the perfect opportunity to do that.
What happens if a business does not comply?
Well, things can get a little pricey.
Okay.
I alluded to various statutes and regulations at both the federal and state level. You have the ADA, Americans with Disabilities Act. You have Title VII, which basically precludes various forms of discrimination. The Age Discrimination and Employment Act, the Fair Labor Standards Act. I could list other federal laws.
Yeah.
There's the Pennsylvania Human Relations Act. And while the state and federal laws are in many ways very similar, there are some important differences. And all of these laws carry their own consequences if they're violated. I'm trying to help employers stay out of court.
Right.
But if there is a violation or even an alleged violation, now not only are you hiring a lawyer to deal with it, if there has been a violation, all of these statutes call for significant penalties.
Got to keep that in mind for sure. So how are you helping employers comply? What are some proactive steps that you're suggesting?
Right. It's very hard to unring the bell.
Right.
What we try to do is keep the bell from ringing in the first place. We look at policies and make sure that the employer has, at least on paper, what they're supposed to have on paper. And more than that, complying what they have on
for
paper.
Sure.
Very often we'll conduct what we'll call a legal audit of their employment practices and their payroll practices to make sure what they're doing is in compliance with the law. We can deal with most situations before a real problem arises. What's hard to do is undo something that's already been done.
I see. I see.
And particularly if it's done on a large scale. If you have one employee where there was a problem, that's bad enough. But if you have a group of employees where there's a larger problem, now that's a real danger. Now that can frankly break a business.
So you're actually having meetings with employers to say, let me review everything, let's make sure you're in compliance so we don't have a problem down the road.
All the time.
Okay.
My goal is to avoid those problems.
Right, to
and
stay out of
certainly my
court.
clients' goals are to avoid those
Yeah,
problems.
I would expect so. So let's pretend COVID is over. What are some of the issues that employers should be focused on or concerned about? What do you want them to have top of mind status?
What I've mentioned once or twice, the biggest risk for an employer, in my opinion, is a large-scale wage payment violation. If you have a dozen employees that you've paid by salary and therefore you believe you don't have to pay overtime, you might very well be mistaken. If one of those employees now says, hey, I've been untreated fairly, there's been a violation of the federal and state laws, that employee can mention it to another employee and you can be looking at a class action lawsuit for a payment violation. I deal with those all the time, unfortunately.
Class action lawsuits against employers?
There are plaintiffs' law firms and that is all they do.
I see.
So this is a sub-industry in the employment law field. And that is the big risk. It's one thing if one employee says, I'm owed some overtime, and it can date back for 3 years. But if a whole group of employees files the same claim, and there's penalty payments on top of the back pay, this now can be a real backbreaker for a company.
So what do you mean by wage and hour and employee classification? Why are those important things for employers right now to be cognizant of?
Well, there's two things when we talk about employee classification. One is under the federal law, the Fair Labor Standards Act, and Pennsylvania has its own minimum wage act. And both of those require overtime pay to certain employees. Most people who work are going to be considered non-exempt, meaning if they work more than 40 hours in a week, they have to be paid time and a half for all hours over 40.
Yeah.
A certain group of employees will be exempt from those overtime requirements. In fact, the law has recently changed in terms of how much money you have to pay somebody. There's a minimum salary threshold for somebody to be exempt. For years, that number was somewhere in the neighborhood of $24,000. That was increased significantly a year ago, and currently it's slightly over $35,000.
Oh, $35,000, okay.
What a lot of folks don't know is that the law in Pennsylvania is different from the federal law. Although those numbers are the same right now, in just a few months, in October of this year, that minimum salary threshold is going to increase to over $40,000. And that's a Pennsylvania law. So employers have to be cognizant of both federal laws and state laws with regard to those issues. So that's one sort of employee classification.
Okay.
The other we often refer to is whether somebody is an employee or an independent contractor. And if you make a mistake as an employer and you pay somebody as an independent contractor and give them a 1099, where in reality you should really be paying them as an employee, that creates its own problems. You could be liable for the back taxes, and they might have certain rights as an employee that they wouldn't have as an independent contractor.
That sounds like a huge deal that an employer has to be really certain about.
It can be. And what can be very frustrating when you talk about these issues is that it's within the employer's control. If an employer does everything right and treats its employees fairly and pays them fairly and gives them a living wage, the employer still can't stop all problems. An employee might make a meritless claim. And that happens. I see that all the time. And there's really very little you can do about it except defend it and say you've done everything right and hope that at the end of the day you won't be liable for any issue. But if you pay somebody incorrectly, that's on you because that was completely in your control to understand what this employee was doing, what position the employee held, and know what the law requires in terms of paying that employee. So there's really, in most cases, very little excuse for an employer to misclassify someone.
That's very interesting stuff. If an employee says they have a disability or medical issue, what should the employer do? What must they do?
Well, these are some of the most difficult issues to deal with for any business, and sometimes even for the HR professionals or employment lawyers. If a health issue comes up, if somebody says they have a medical issue, little bells should be going off in your head. And the word disability doesn't even have to come up in the conversation. But as soon as somebody says, I've got a health problem, I need this or I need that, or I'm having a problem because of an issue, immediately an employer should be thinking, okay, I have an ADA situation, Americans with Disabilities
Bing,
Act.
that should go right up, yeah.
Correct. And unless the person has some expertise in the ADA, they really need to consult with their HR team or an employment lawyer to help manage these issues, because most of them are manageable. The law requires the employer speak with the employee and determine if there is in fact a disability, is there a reasonable accommodation so that this employee can perform the essential functions of the job?
I see.
Very often there is a reasonable accommodation. Sometimes there is not.
Yeah.
But what the accommodation is going to be different. It depends on the nature of the person's health issue, the disabling condition, and of course the job. The employer doesn't get to decide what the reasonable accommodation is, nor does the employee. The law requires they basically have a conversation. In legalese, we call it the interactive process. But simply put, it's a give and take to determine, okay, what is your issue? What's the job? Let's see if we can work together to figure out how we can change what you're doing here a little bit so you can do this job. Somebody with a back problem might need a special chair. Somebody with another issue just might need to take short breaks during the day. Somebody might require a little bit of unpaid leave. It's different for everybody.
Well, you bring up another point, which is turnover. When people are unhappy and they leave. And that's probably happened during the pandemic a lot, people looking for new opportunities. So does that create any issues for your clients, for employers, or even for employees?
It can. Very often when employers are hiring somebody new, or if they've lost an employee, there can be a situation where there's a violation of a restrictive covenant, or what most folks would call a non-compete agreement.
Yeah.
A non-compete agreement is simply a written agreement between an employer and an employee that says, while you work for me, or for a period of time after you leave, you will not compete against my business. Or it can be a non-solicitation agreement. You will not solicit my customers, or even my employees. It's a way to protect the employer from having an employee who learns the business, gets trained by the employer to know the business, learns the customers, develop relationships with the customers, from taking those key employees and working directly against their employer.
Are they enforceable?
They're enforceable if they're written correctly. Typically, these agreements are signed at the time when somebody starts their new job. If an employer wants an employee to sign such an agreement after employment's already begun, there has to be what the law calls consideration, tit for tat.
Tit for tat.
If you're going to have an employee sign this restrictive covenant, you've got to give the employee something in return. A raise, new responsibilities, some benefit. Otherwise, the agreement will not be enforceable. There is plenty of litigation over these issues, and I was involved in the case, about 18 months ago for a medical device manufacturer where a salesperson thought he could jump ship to a competitor despite having one of these non-compete agreements. We filed for injunctive relief, which is simply when you go to court and ask the court to enter an order stopping this person from violating the restriction and working against you. Well, this person just bought a house, had a new child, and thought they could jump ship and take their clients with them. We were successful in enjoining that employee, and that employee then was out of a job. Unfortunate for him, but it was absolutely necessary for my client to protect his business. So they are enforceable if written correctly.
That's interesting, because I wanted to ask you, does this ever occur? And it sounds like it is something that happens in the workplace quite frequently if people have signed non-competes.
It happens all the time, and I can't recall a period of time in the past 10 years why I have not had at least 1 or 2 active cases involving these issues. And I'm reviewing them or drafting them for both employers and employees on a regular basis.
So as many people have found themselves out of work this past year, have you seen a rise in wrongful discharge claims?
We're starting to, and I haven't seen statistics from 2020, but they'll come out through the EEOC or the Human Relations Commission. When you have a disability claim, when you have a discrimination claim, you can't run to court right away and sue your employer like we can in most things in the United States. With disability claims, before you go to court, you have to file what we call an administrative charge through the Pennsylvania Human Relations Commission or its federal equivalent, the EEOC, the Equal Employment Opportunity Commission. Only when those administrative agencies have had a chance to investigate and look into the allegations can the next step be taken and the employer and the employee file suit in court if things are not resolved at the administrative level. But we're seeing certain disability claims, and the fact of the matter is, the more people are out of work, the more people are going to be filing wrongful discharge claims and alleging some sort of discrimination, even if it's not really true. I had a client recently get served with a claim of discrimination in the EEOC because a person was let go following an injury. But the injury had nothing to do with the decision to let that person go. The person could have done the job easily whether he suffered the injury or not. The decision in this case was completely COVID related. They unfortunately had to let a number of people go last spring, but this person filed a claim anyway. So we're starting to see things like that creep up.
Reminds me of sort of another issue, which is one employee's upset about something, files a wrongful discharge claim. The person who sat next to him says, maybe there's a claim out there for me too. Do you see that kind of snowballing when an employer has multiple employees kind of looking disgruntled all of a sudden because someone has filed a lawsuit who used to sit next to them?
Now and again, and it depends how the person was treated, the reason the person was let go, if that's the situation. Very often, if there's a former employee and you want to resolve a claim with that person, there will be a confidentiality agreement associated with any resolution of that claim. Just so the other folks in the office aren't made aware of it and get the same idea in their head to do something similarly, whether just or not.
Gotcha. So what's ahead with the Biden administration? What do you think is going to be happening from the employer's standpoint?
Well, the Biden administration has already started to roll back some of the changes that the Trump administration tried to make in the weeks and months before the change of administrations. There were several regulations that the Trump administration tried to put through affecting independent contractor status, affecting joint employers, involving the tip credit. And when I talk about the tip credit, that's the situation where primarily restaurant workers who don't make quite the minimum wage because they get tips. There's something called a tip credit. Various regulations were put out by the Trump administration, and the Biden administration has now said, not so fast. We're putting all of these on hold. We're going to take a hard look at these. It will come as no surprise that the regulations put forward by the prior administration were more employer friendly.
Yes.
And the Biden administration has said, no, we're going to look out for the employees a little bit more, so we'll take a second look. And of course, if anybody's been following the news at all, the minimum wage is a huge topic right now.
Right.
The administration and the Democrats in Washington tried to push through a hike in the minimum wage, which is still at the federal level, $7.25 an hour. They want to up that to $15 an hour gradually.
Right.
They were unable to put it into their coronavirus relief package that recently passed. I'd be stunned if there weren't more significant efforts to try to get that through in the coming year or two. Mm-hmm. And also at the state level, Governor Wolf has made it no secret that he is pushing, along with other Democrats in the Pennsylvania legislature, to increase the mandatory minimum wage in Pennsylvania, as some other states have done.
Well, all of this tells me that if I have an employment law question, I've got to call you. That's what all of this tells me, because you're on top of the Biden administration new rules, past rules, current rules. As we end today's interview, could you tell us a little bit about, or maybe just tell us the top 2 things employers need to know or do or think about right now from your standpoint to be protected?
Right. Have a basic understanding of what the laws are going to require of you, and put policies in writing if you don't have them. It's not that a written policy protects you, but if you have something in place, you're a lot more apt to follow that policy or go to it when a situation arises. And it's also a little self-awareness. If you are not familiar with these various statutes, it helps you become aware. Mm-hmm. And again, you don't have to be familiar with the nitty-gritty of all of them, but you do have to be able to spot an issue and think, gee, this situation has arisen. This could lead to a problem here, it could lead to a problem there, and you know to ask the question so you don't make a mistake.
Okay.
Second, and I've harped on this because to me it's far and away the most important, figure out your compensation packages for your employees. How am I paying my employees for this position or that position? Does it comply with the law? As the overtime regulations change, as minimum wage perhaps changes, am I going to be able to manage my business like I'm managing it now? Or is this going to be a real problem for me?
Okay, well, I think those are fantastic tips. You've just convinced me that for any business that wants to be successful, they need to stay in compliance. And I can't thank you for how easy the information was you just imparted. You really have a huge handle on it, and I thank you so much for taking your time to be here with us today.
Thanks for having me.
So, folks, if you have any questions for Ethan on the topics that he covered, I know he'd be delighted to speak with you. His contact information is being shown now on the screen, so you'll know how to reach out to him at his law firm. On my next show, my next guest will be coincidentally a partner of Ethan's, whose name is Bill Rourke, who's the head of the marijuana and hemp law practice at Hamburg, Rubin, Mullen, Maxwell, and Lupin. Bill is one of the leading lawyers in the marijuana and hemp industry and is currently representing national and local businesses involved in this explosive industry. So if you want to send me any questions in advance to ask Bill or any future topics you'd like us to have on the show, please write me at stacy@stacyclarkmarketing.com or go to stacyclarkmarketing.com, my website. So please share with friends and families what you've heard here today. It's been fantastic information from Ethan O'Shea, and we'll look forward to seeing you next time. Thanks for watching.